having security standards to protect the data, to avoid data breach, I think is very critical because the penalties can go up to 250 crore Indian rupees or about $28 million.
Companies hoard data and they have a big time bomb ticking under the DPDP Act because it doesn't allow you to store data. So I think companies need to figure out what data they need and how long they need it for.
Courts are overburdened probably because there are just too many matters. So arbitration and mediation are giving the necessary push, but I think still the court is just too burdened.
I always, whenever I do any search, I always look for the source. Is that a good thing, good practice, just for everybody's general knowledge?
Absolutely. Always check the source.
Always check
the source.
Welcome back to Transforming India, the road to 2047, presented by Mint in partnership with JSA Advocates and Solicitors. I am your host, Alokesh Bhattacharyya. I am the Deputy Managing Editor of Mint. With India's digital economy projected to reach $1 trillion by 2030, safeguarding data and regulating artificial intelligence have become national imperatives. The Digital Personal Data Protection Act, along with emerging AI governance norms, will define how innovation can thrive responsibly in a data-driven economy. To unpack this, I am joined by two legal experts who are at the forefront of India's technology and privacy law evolution. First, we have Raj Ramachandran, who is a partner at JSA who advises clients on technology, law, privacy and regulatory compliance. With more than 2 decades of experience, Raj has been deeply involved in shaping strategies around data governance, cybersecurity and digital transformation for global as well as domestic enterprises. With him here today is Probir Chowdhury, partner at JSA. Probir specializes in technology, media and telecom law with a strong focus on data protection, e-commerce and cross-border privacy frameworks. Probir has advised leading technology companies and startups on navigating India's emerging digital and AI regulatory landscape. So, welcome to the podcast, Raj and Probir. Really happy to have you here with us today. Looking forward to your insights. Let's start with a rapid fire, right? What we call the rapid 5, because we have 5 questions here and both of you can answer them. The first is data protection. Is it over-regulated or under-regulated?
I can go with this one. It seems to be both, unfortunately. There's a bit of over-regulation and under-regulation. Over-regulation in that there is a lot of government discretion, in exercise of the powers, right, to grant exemptions, for example, to blacklist jurisdictions. Those are all overreaches in a way. Under-regulation in a way because there's very little for the actual consumer. There's no remedy, there's no mechanism where he can receive a compensation if there's a breach. So as of today, it's a mixed bag. It's a bit of both.
Most unexpected response.
Yeah, I like to call it a balanced. It has to be a balanced approach because I think a lot will be dependent on the implementation of the Act. And that would really depend on how the Data Protection Board and Authority actually implement the Act, because this whole Act is going to be subject to a lot of judicial interpretation. It's the first time India has actually come up with something like this, so it's going to be a balanced approach to this.
It's quite a complex area,
yes,
even for our judges and the judiciary, and even for you all, I guess.
Yeah, we don't have precedence on this.
Don't have precedence, yeah. Okay, next question, artificial intelligence. Is it a risk or an opportunity?
I think it's an opportunity. Definitely, it's just a question of how you harness it, because AI is taking over the world. It's affecting everyone in every aspect of our lives, legal professionals for sure, companies. So it's an opportunity and we have to tap into it.
Okay.
Right. Yeah, no, without a doubt, because every matter, for example, it can be transformative. Let's say for healthcare, for example, it can be transformative. It can help with drug discovery, so many other matters, right? But let's say climate change, for example, you can predict something and direct your policy initiatives in that direction. So it is going to be transformative. The only thing is, today there is no regulation around it, so we don't know how the data mining happens, what data is collected, what is secondary repurposing of those data. So to the extent, it's a little black box, so to say. But of course, it is beneficial.
As long as they don't start killing us, it's fine, I guess. Right? Okay. Next question. A global privacy regime that India can learn from.
It's the GDPR. Naturally, that's the foundation of it. So the best would be to look into that and try and have those learnings from that law, from the precedents that we already have, rather than trying to reinvent the whole thing. I think the whole precedent has been set. They have practically enforced the law, so it'll be easy for us to use that as a base and then move forward. So that although we've been late in implementing the law, at least we'll now keep pace and move ahead fast.
I think some of our companies have also experienced the GDPR. Right?
Yes.
Those were companies who are dealing with European partners.
That's correct.
While of course GDPR is a precedent, and I think India tried to emulate GDPR, another jurisdiction which is often overlooked but is actually very business friendly is the Singapore regime.
Yeah.
They have a very good business oriented approach towards data protection. They recommend advisory actions rather than punitive actions for breaches. They allow self-compliance, self-declaration. So I think while GDPR of course is the benchmark, it will also be good to look at the Singapore law and see how the Singapore government has been sort of enabling businesses and advising its citizens, because as India sort of goes on this digital transformation journey, it will need to look at its neighbors. And Singapore is very close to us. It's an Asian country, a very good equation with Singapore. So it could be another jurisdiction we can look at.
Self-regulation
Yeah.
or self-compliance, is it a good idea in India?
If business has to grow and foster, you have to allow, well, you already actually have a precedence. Look at the Advertising Standards Council of India, right? AACI is a self-regulatory body, right? They have come up with guidelines, and it has been going on for a while. So, right, even the fintech industry would have pushed and liked for self-regulation. So I think the government it has to be sort of a marriage, right? Someone has to give, someone has to take. So a little bit of self-regulation and allowing company to grow is important.
Let's hope that we in India start moving more towards self-regulation instead of the other way around. Okay. Next question is the biggest compliance blind spot in AI.
So the blind spot is just the lack of transparency, right? From where the data is being gathered, how it is being used. There's clearly no consent requirement. There's no purpose-driven access or analysis. So according to me, see, the devil is in the detail, therefore, so every point of view, every opinion that we give, every point of view is very specific, fact-based and contextualized. So unless AI is able to give that fair, contextualized responses, it will always remain a blind spot, because you don't know the training data that is fed into the system will also to a large extent influence what the output is, right? So the training data is not fair, the output is not going to be fair, right? So therefore, to that extent, artificial intelligence only that much it can do, because it's going to only analyze what is given to it. It doesn't have a level above to say we'll go beyond the scope of what the parameters have been set when giving the data.
Totally agree with Raj. The training database, that has to be, companies are using data, has it been lawfully obtained, has consent been taken, are there biases, right? Because all of this is being fed into the LLMs, right? So it's very important that this blind spot on training data has to be captured and has to be affected. Otherwise, it's going to cause a lot of problems. That's the serious blind spot on AI.
Several of our visitors and those who are watching us use generative AI tools like ChatGPT and Gemini and Grok and several others. So, would you recommend, like I always, whenever I do any search, I always look for the source of anything that the generative AI is telling me. So, what's the source?
Yeah.
Right? Is that a good thing, good practice just for everybody's general knowledge?
Absolutely. Always check the source.
Always check
the source.
Always check the source. Okay. Right. Next question. One word to describe India's data law.
Foundational.
Evolving.
Evolving. Nascent is more like it.
Yeah, hence evolving is slow.
Right. Okay, so now the quick five is over. We move to our main section. And we come to the first question, which is to Raj, on data protection compliance, which is that with the Digital Personal Data Protection Act, which is now in force already, what are the compliance imperatives, the key compliance imperatives that companies operating in India that they need to prioritize?
So the act has received the assent from the parliament and the president, but has not been notified to come into force yet. The draft rules were out for public comments, but they still not have been finalized. So we are there, but not yet there. Consent, it's consent driven, completely consent driven. So seeking consent is a key compliance criteria, form and manner in which you seek consent. What purpose are you seeking the consent for, and what purpose will you use it for? I think that is also a key compliance requirement. Erasing of data, either after the purpose is achieved or where there's a request for withdrawal is also another key compliance. Right. Having security standards to protect the data, to avoid data breach, I think is very critical, because the penalties can go up to 250 crore Indian rupees, or about $28 million today's exchange rates. And the burden of penalties also equally there when there's a non-reporting of a data breach. Right. So broadly, I think these are the key compliances to be looked into.
Right. So then we move to the next question, which is for you, and it's on enforcement and corporate behavior. So regulatory enforcement has the potential to reshape how organizations collect and process data. So how do you see India's approach evolving? Will enforcement be collaborative or coercive?
I think the approach will have three phases. There'll be an initial phase, a transition phase, and the mature phase. The initial phase, because we have a 18 to 24-month implementation period, and this is the first time we are going to have a data protection authority, right? So I think they're going to collaborate, and they will need to collaborate with the industry to phase out this whole implementation of the act, right? Work with organizations, and that's what we have also heard based on our consultations with the government and the regulator. They're looking at a consultative process to lay out and roll out the act. It's not a head-on approach, it's a collaborative approach. So that's the first phase, going to be collaborating, getting feedback from organizations, allowing companies to build institutional capacity, right? Because implementing this is not going to be easy for organizations, right? And we're not talking about the global organizations. There are Indian organizations which have startups which have grown to full capacity, are operating on a very large scale. They're processing and collecting a lot of data. They need to have processes in place. So I think that's going to be the first phase, sort of a collaborative phase. The second, which is the transition phase, is going to be where I think the regulator is going to start taking effective actions, right? They want to be taken seriously. They don't want to be considered as a toothless, because they do have, as Raj just mentioned in the previous question, right? They are empowered. They have the authority, and they're empowered to implement fines on defaulting companies. So the second phase is going to be where they're going to take effective decisions and implement penalties on companies which are actually violating the law, and probably something like the CCI and the SEBI, right? They're known as effective regulators. They interact with the organizations, they work with companies, but they also lay down guardrails within which they penalize companies. And the third is going to be the mature phase, in which the regulator is going to look at certain specific sectors, like sensitive sectors, like the healthcare, right, financial institutions, and they're going to focus more on organizations who are collecting, processing volumes of data, and are they actually complying with the law. Then they're going to look at class protection, children's data, right? It's been a big issue in our legislation, right? And in fact, India has surprisingly been at the forefront of, calling out the strict compliance that companies need to do when collecting and processing children's data. There was a lot of hue and cry by the media companies, because they were like, how are we going to actually implement it? And in the third phase, the government is going to look at class protection to see, one is the kind of data you are in, the kind of sector you are in, and class protection for children's data or minorities. And that's how I think really the phased approach towards implementation with the regulator is going to work out, and they will actually look at implementing penalties or pulling up companies in these sectors.
Just aside, one of the things that I'm thinking is that startups you mentioned, and you mentioned some key sectors. The next question for Raj is on certain sectors. But startups are digital native guys, right? They're all IIT pass outs. They know technology at the back of their hand. For them to adapt to something like this is going to be easier than the vast majority of Indian companies who are smaller, like the MSMEs or even the mid-sized companies who may not be so data aware, right? Is that going to be a challenge, you think?
I think definitely a lot of the traditional Indian companies who are not on sort of the tech sector will take some time to implement, and I think that's the government's approach also. They do want the high-tech sector, the global companies who are processing large volumes of data to actually start complying with the law first, and that's where the sort of phased implementation period, right, to help organizations build capacity. And we as a law firm have been doing these training modules uh, across different sectors, because this law is sector agnostic, right? It applies to anyone. So we've been in training modules for all our clients in different sectors and making them aware of how the law applies to them. I think first is to understand the law applies to you, and then to realize you actually are collecting data sets, right? That analysis to figure out that you have data that applies to you itself is the first step, and then of course implementing the law.
It's a huge area. It's a huge area, right? And it impacts practically every sector, every size of business. Thank you for that answer. Next question is on AI and legal risks, and I come to Raj for that. AI is already driving decision making in finance and healthcare, like we said, even recruitment, right? So, what are the biggest legal risks you see with AI-driven business models, especially when algorithms are biased, which happens frequently? There's a lot of concern about ethical AI and biases in the data that you're feeding, like you said, the data that whatever you give the AI, it will use it. So if that is biased, then there's a problem, right? So what are the legal risks that you foresee in this?
So legal risk largely is sort of accountability. Who's going to be held accountable, for a decision, for a conclusion, right? There should be some sort of justification as to why a certain decision has been arrived at, what is the conclusion to it. Right? The parameters surrounding, the training data provided. What kind of data has been provided? Are they biased? Are they unbiased? Do they represent the relevant population, right? Because underrepresentation, overrepresentation can also skew the results one way or the other, and the answers can be completely wrong, right? There are also several stakeholders. There is the AI tool, then there is the party who's feeding the data, the party who's setting the parameters. So we don't even know how you will be able to identify who is in the wrong. So there has to be somebody who looks into these and says, these are the broad parameters, like we have in the EU, right? You say these are high risk matters, and therefore this will be subject to higher scrutiny, higher degree of scrutiny, and then the low risk ones are still okay. But we cannot broad brush everywhere and say that all the rules will be common for everything, right? For example, past trends, right? It could be, for example, the healthcare or financial sector, like Probir was saying, right? Or even employment related matters. Does your past history affect your future conduct, right? There could be two aspects to it. It could be a past poor credit score. Will it impact your future? Can it be a past, employment-related issue which can impact your employability in the future, right? And therefore, the right to forget, the right to erasure is also equally important. So, when either we are trying to get very specific to say it should not be a generalized response from an AI, but while being so specific, it should not be prejudiced. And therefore, if you intersect the two and say yes, it will be specific, it will not be generalized, but we'll also give you the right to forget, the right of erasure. So you come to a conclusion that it works well for everybody. I think that should be the norm. Also, sometimes you see that the likelihood based on past data trends, right? Is this a trend? So predictability, like you're saying, generative AI, if you go with predictability, it may or may not be right. It may not be accurate. There might be a gap in it. So that also is again how much weightage do you attribute to facts, to the general strata of the population and to the likelihood. I think all of that will play a role.
Right. In fact, it's sometimes feel that this is possibly the biggest challenge surrounding AI in terms of, because we are human beings, right? We all have our biases, no matter where you are from.
Yes.
Exactly.
And whatever you feed in will reflect your biases in some way.
Today also, if you do a search, for example, I think there's a disclaimer which says AI results can have mistakes. The question is, are you reading the disclaimer? Are you going to read the disclaimer, and are you going to discount the result, and to what extent are you going to discount the results?
Yeah.
Because a mere disclaimer is not going to help.
No, even the generative AI tools like ChatGPT and all, they have the disclaimer.
They have the disclaimer. Exactly.
ChatGPT can get it wrong, so you better get it checked.
Right.
Interesting. Okay, another question. This one is for Probir, and this is another big debate that we keep having in conversations all the time, which is about innovation versus regulation, about regulation stifling innovation or innovation just sort of hitting the borders of what is right and what should be done. So the global debate around AI regulation has intensified, right? The EU's AI Act, for example, which classifies systems based on risk. How should Indian companies balance innovation and responsible AI governance frameworks without stifling growth?
I think we have an opportunity. We don't have an AI Act, and Indian companies actually have the opportunity to balance innovation and regulation. And a lot of this will come back to companies on how they're looking at setting up processes internally. They can take a three sort of pronged approach to this. First, they can look at setting up responsible tools in uh, high data sectors. Like if you're in the financial sector, you're in the healthcare sector, what are your governance tools? How are you actually ethically collecting data? So you end up looking at those sectors and you end up focusing your governance policies without yet getting into regulation. So if you start innovating along with governance or good governance policies, especially in these sectors, because the government will also look at these sectors more critically, right? So if you're looking at what the West has done and you start incorporating these policies into your own high risk sectors, you will find that you will be able to innovate and yet be balanced. And the second one is what I think you also mentioned before is, the self-regulation. Like I mentioned that, yeah, because self-regulation is so important because you already have that in the country, right? You have NASCOM, for example. I mentioned AHCI, right? In fact, the fintech sector, they were supposed to set up a body, right? So the government is always encouraged, even the gaming sector, the government wanted industry to come together and form guidelines because it's always good if industry players come together. They understand the business, they understand the risk, they understand the practical issues that they are operating in, right? Why would you want the government to lay it down? You would rather have a governance framework which you set up. So I think having a self-regulation and sector-led framework will help them innovate. And third is, I think, harping on the fact that because we've seen in the past that governance has to be built into your process from day one. Set up your data AI ethics board, set up your governing policies and principles, train, train and implement this with your local management, your grassroots level people who are collecting data, and build governance and checks and balances into the process. Because it's what happens often, and that's what we have seen in the tech sector, and really a lot in the fintech sector, because that's sort of been the progress in the past 7, 8 years the government has seen, the country has seen, and why you've seen the government now over-regulate the fintech sector. Like you keep on hearing stories that the fintech sector is being over-regulated, the government is coming out with so many regulations. Why is that? Because the government let innovation happen, and when you let innovation happen without regulation or self-control, that's when processes are left, no one follows checks and balance systems. So we have a chance, instead of being over-regulated, if we start, when I say we, companies start looking at how they are building their processes and start self-governing tools in the process of collection data and implementing AI tools, having ethics board, check and balance system audits, then they will find that there may not be a need for over-regulation by the government.
But there would also be in the intensely competitive world, there would also be this inclination to just sidestep certain things and let me get a competitive edge over.
You'll always have bad actors. You'll always have bad actors, and that is what the government is going to come up with regulation, right? Like I don't know where the government is going to go in an AI Act. We're talking about AI, right? The government has also done a bit of a dance on AI. First, they have said we will regulate AI. We will not regulate AI. You can't regulate AI. Now you suddenly have the EU AI Act, right? Just like GDPR, we emulated our data protection law from GDPR, right? So
both are from EU.
exactly. So we may end up looking at the EU, but we also realize that GDPR was very tough for us to implement, right? So our act is no longer a GDPR act, right? We have gone back to a consent-based framework, which was already there. If you look at the IT Act, it always requires you to get consent, right? So we've ultimately gone back to what we know best. So my point is that at the end of the day, that you can look at what the EU is doing, but you have a chance. Indian companies have learned, so they have a chance to actually build governance into their processes to hopefully balance innovation and regulation.
Self-governance.
Yes.
Ultimately, not only govern your own company the right way, but companies in their industry can come together, right? From outside of the framework. Good points. So we come to the fifth and last question in the main section, and that's again for Raj. It's on global convergence. So India's data law is still evolving alongside international regimes like GDPR, which we discussed just now, and even the US privacy frameworks. So are our laws keeping pace, with global standards on data transfer, on AI liability, and cross-border compliance?
Well, one the act is not yet in effect, so it's yet to come into force, but largely modeled on GDPR. But like Probir also mentioned, we have strayed away, because that is a more difficult compliance requirement. We are sticking to how we used to look at compliance and consent under the IT Act. There are some differences, of course, because today, originally it was proposed that there will be a whitelisting of countries for transfer of data. Now it is the other way around. It is going to be generally permissible unless a country is blacklisted, right? That's not the general norm. The general norm is to see whether the data protection laws in the country, the transferee country or jurisdiction, is comparable to the GDPR compliances, right? That's one difference. Another difference is Indian authorities have the right to also notify significant data fiduciaries, right, which could be a single fiduciary or a class of fiduciaries for whom the compliance requirement will be higher. There will be more monitoring, more closer audits. So in that sense, while we have stayed with the core of it, I think we have also adapted some of those to meet our requirements. Overall, I think it's an open-ended law, right, leaving a lot of room for flexibility to see how the law evolves, and therefore a lot of flexibility is given to the government. The rules are also a little broader than originally how they were conceptualized, but I think that's where we are.
Great. Okay. So now we come to the closing rapid fire, another rapid fire. So this is open for both of you again. What is the biggest legal risk that businesses often ignore?
Data minimization. Companies hoard data, and they have a big time bomb ticking under the DPDP Act because it doesn't allow you to store data. So I think companies need to figure out what data they need and how long they need it for.
And of course, I think there are also multiple regulatory frameworks, right, for companies who operate in multiple jurisdictions. They will be governed by multiple laws. To have a clearer understanding of the compliance requirements in each of those jurisdictions, I think is also key.
That is the most difficult thing to keep track of, which is why I think they'll come to you ultimately to figure out how.
Yeah, because it's law, then there are judicial decisions, and there will be orders by authorities. There will be so many variations to each one of them. To keep track of them, I think is going to be a challenge.
Indeed, indeed. Okay, next question is one regulatory trend that everyone should watch.
Convergence of AI and data. As companies are going global, they are operating on a global scale. You're no longer a national company or a regional company. Everyone is a global company, which means there's always going to be, and taking from Raj's point, there is going to be a cross-pollination of global compliance laws, right? And that is something that companies need to be aware of. Multi-jurisdictional compliance with data and AI, it's going to impact everyone.
Report, Raj?
No, I think it's right because they also looking in two different directions. If you look at generally, AI is no purpose driven basis, right? It is less transparent and is overarching. While privacy is completely the opposite of it. They're clearly looking in the opposite direction, right? So to bring them together, I think is going to be a challenge.
Indeed. Okay. Most common mistake clients make in tech compliance. You guys are the perfect people to answer this.
So I think exactly what Probir said, right? Data minimization, you should know what data you have, why you're having it, why you're holding the data. If you don't need to keep it, don't keep the data. Continued training, I think, is very important. Train your relevant stakeholders, your teams, your departments with the updated requirements under law. I think those are key to continued compliance.
Retroactive compliance, which Indian companies are famous for, right? You first try and build the business, and then you try and fix the legal loophole. I think this they'll have to really work on. It's a mindset change.
Retroactive brings back nightmares of retrospective taxation and all that.
So
Okay, is this another thing that you need to watch out for? Okay, an underrated legal reform that India urgently needs.
That's easy. That is our unfortunate Tariq pe Tariq issue. We never get to a conclusion in any matter, right? Courts are overburdened, probably because there are just too many matters, right? So arbitration and mediation are giving the necessary push, but I think the court is just too burdened, right? The only way you can address it is to have fast track courts, take the procedural matters like capital protection matters, merger matters outside the purview of the courts and the tribunals and give them to the regulatory bodies. I think that is the way to do it. I think otherwise today the judiciary and all cases just work on interim reliefs. That's where we are, right? We never get to the final order stage. We just work with interim reliefs. And, by the time justice is delivered, I think it is almost ineffective to the point that even the system discourages, a good actor from pursuing a claim, because of the inefficiency in the system. That's really unfortunate.
Yeah.
And taking a shift away is a modern competition law to address digital markets. India tried to do that, and we need to have updated competition law for digital markets. They just pulled out the act which they'd introduced, but they need to work on that.
Right. Passing on some of the stuff to regulators is a good idea, but then again, that would mean that if the regulator gives a certain, verdict, you don't like it, then you have to have the option to appeal, right?
That is
You
right.
cannot take that away. So again, the whole cycle.
Yeah. So in the quest for following the principles of natural justice, I think it's just taking just too long, right?
That's something that cannot be helped. Okay, last question. In one word, your view of India's regulatory future.
I would say transformative because I think we have made strides in a lot of sectors. Like financial inclusion has been really, really transformative. But in some areas, well, of course, we are evolving, but transformative, I would think.
Okay, transformative.
Assertive.
So,
We have seen the RBI specifically in the fintech sector come up with very stringent guidelines and enforcement. So I want to say the way the regulator is looking, I think, is going to be more assertive, definitely.
right, so we come to the end of our discussion. Thank you so very much, Raj and Probir, for those insights. I'm sure you have also learned quite a bit today. As we heard today, India's journey to $1 trillion digital economy will depend on how well we balance innovation with accountability. Clear guardrails for data protection and AI governance will not only protect users, but also empower businesses to innovate with confidence. So that's it for this episode of Season 2 of Transforming India, The Road to 2047, presented by Mint in partnership with JSA Advocates and Solicitors. I am your host, Alokesh Bhattacharyya. Until next time, stay future ready. Goodbye.